thank you for joining us for today's webinar on immigration law, preparing for the future Tier 2 sponsor licenses. I'm Jill McKerney, Head of Immigration and a Senior Associate in the Employment, Pensions, Immigration and Compliance, or EPIC team, and I'm joined by Pip Haig, who is an Associate in Team EPIC. This webinar is intended for companies who currently hire or may wish to hire workers from outside the UK. This session is one of 12 webinars hosted by the Fieldfish EPIC team. We will be hosting a 30-minute session every Tuesday at 1 p.m. covering various hot topics. If you have any questions about today's topic, please use the question box on your control panel on the right-hand side of your screen. We will then collate the questions and answer as many of them as we can at the end of the webinar. If we don't manage to get to your question, we will follow up with you directly. All of our sessions are available on our website and on our YouTube channel. By way of providing context to this webinar on sponsor licensing, the UK left the EU on 31st of January 2020 and is currently in a transition period until 31st of December 2020. Michael Gove has confirmed to the EU that the UK will not extend the transition period, meaning that free movement will end on the 31st of December 2020. The government has announced that they will bring in an Australian-style points-based immigration system from the 1st of January 2021. Together, these changes will comprise the most significant developments in UK immigration law in 40 years. With less than 6 months to go until the changes take place, we look at the countdown to the new immigration system and what will change, what are the sponsor license requirements and how to apply, the action existing sponsors should be taking now, and a brief look at the EU settlement scheme. The government issued further details on the new system yesterday, and we incorporate some of these details in the webinar.
So why is it important for you to know about sponsor licensing? The upcoming end of free movement and the implementation of the new immigration system is going to affect all employers and businesses and require them to take some kind of action. Applying for or maintaining a sponsor license will be a key part. This is what we're going to bring to the fore during this webinar, along with stressing that there are fast approaching deadlines by which you should take action. Workforce mobility, workforce continuity, and immigration compliance are key risk areas for businesses. You need to be able to recruit and move your key staff as and when needed, easily and swiftly. Businesses should ensure they understand the challenges and commence preparations to secure their current and future workforce. We'll briefly take a closer look at the upcoming deadlines now, and we'll go into further detail on this later. Firstly, with the end of free movement on the 31st of December 2020, which is just around the corner in 5.5 months, every EU national wishing to continue to live and work in the UK must take action to protect their immigration status by applying to the EU settlement scheme. To be eligible to apply to the EU settlement scheme, the person must have arrived in the UK before 11 p.m. on the 31st of December 2020. Secondly, from the 1st of January 2021, EU nationals who are not eligible for the EU settlement scheme will require a sponsored visa to work. This change will affect UK employers who may wish to recruit workers from an EU country at any level. EU nationals wishing to apply for visas from 2021 will need a job offer from an employer, and the employer must hold a sponsor license to sponsor them. Currently, a sponsor license is only required where an employer is hiring non-EU nationals. Sponsorship is being opened up to include intermediate or A-level skilled roles, including for non-EU nationals, where currently only degree-level roles can be sponsored. Lower skilled roles cannot be sponsored, meaning that employers who rely on lower skilled EU national workers or contractors will require a careful workforce planning. If you're an employer planning to sponsor migrants from 2021 and are not currently an approved sponsor, you can submit an application from now onwards. Finally, eligible EU nationals must apply to the EU settlement scheme by the 30th of June 2021, and we'll come back to this later. It may be helpful first to look at the current system and then what's changing. So currently, there are minimum skill and salary levels in place, which means that people can only be sponsored in certain roles which fall in a degree level job category, and they must meet a minimum salary requirement of £30,000 for experienced workers, and the minimum salary level for the job code for particular roles which may be higher. Apart from some exceptions, the sponsor needs to carry out the resident labour market test to advertise first to local workers for a minimum period. The number of people applying from outside the UK is restricted to 20,700 per year, with some exceptions. Applicants need to meet the English language and maintenance requirements. So what's changing? So from January, a sponsor licence will be required to sponsor both EU and non-EU workers. Employers will be able to sponsor a much wider range of roles, all at A-level standard and above are eligible. The minimum salary requirement is going to fall to £25,600 for an experienced worker, and it's going to be possible that they can trade points in some cases to qualify with a lower salary. With employers currently finding the sponsor licensing system excessively burdensome in terms of administration and costs, the government said that this new system will be streamlined and it's going to simplify the process. The English language requirement will remain in place.
So who will you be able to sponsor? And why have the rules changed? The Migration Advisory Committee were commissioned by the government to analyse the current immigration system and highlighted that 70% of resident EU citizens arriving in the UK since 2004 would be ineligible for a skilled work, family or student visa. The strong consensus among stakeholders was that the salary thresholds were too high. The MAC found that there was little evidence of undercutting migrants in the labour market, and they recommended to reduce minimum salary and skills levels. However, they have excluded what they considered to be lower skilled workers from sponsorship, despite forecasting that there would be significant fall in EU workers in these roles as a result, which could cause skills shortages. The government policy statement said that we need to shift the focus of our economy away from a reliance on cheap labour from Europe and instead concentrate on investment in technology and automation. Employers will need to adjust. They also said that the focus of the new system is a high wage, high skill, high productivity economy to ensure that migrants have a positive impact on public finances. So we'll take a look at some examples of positions which are currently eligible for sponsorship and those that will only be eligible from January. Currently, the minimum skill level is graduate level, and examples of eligible roles include civil engineer, HR manager, software developer, architects, and accountants. So looking at examples of roles which are not currently eligible for sponsorship but will be from January, these include hotel, restaurant and catering managers, managers and directors in retail and wholesale, IT technician, fashion designer, electrician, builder, butcher, baker. This means that for many, sponsorship will become an additional tool businesses can use to address labour shortages where this was not previously an option. The retail, hospitality and construction sectors in particular are likely to benefit, but there'll be added flexibility for most industries. The caveat is that sponsorship is costly. On top of the standard visa fee, the immigration health surcharge will rise in October to £625 per year, and there's an immigration skills charge of £1,000 per year if the sponsor is a large company, or £364 per year if they're a small company. So a 5-year visa can range between around £6,000 to £10,000 in government fees per person. In addition, businesses may not be willing to take on employees where they have previously relied on contractors or agencies for the supply of labour. So when it comes to plugging skills gaps left by falls in EU migration, employers will need to weigh up the cost and benefit of sponsorship. So we'll look briefly at how points can be traded in the new system. So you need a minimum of 70 points, which you'll get 50 points with a job offer, a job at the required skill level, and with meeting the English language requirement. You'd normally get the extra 20 points through your salary. If an employee will earn less than the overall minimum salary of 25,600, but no less than 20,480, they may still be able to apply by trading points on specific characteristics against the salary. However, they'll still need to meet the listed going rate for the role in the job code, which may be higher. So for example, if you have a university researcher in a STEM subject wanting to apply with a salary of 22,000, they won't earn points for their salary, but they'll earn 20 points if they hold a relevant PhD in a STEM subject. and will still be able to apply. Similarly, if you have a nurse wishing to come to the UK on a salary of 22,000, they would get 20 points for their role in a shortage occupation and would still be able to apply.
Now that we've looked in depth at the changes and the challenging opportunities that these may pose, we want to look at what action your business needs to be taking to prepare, whether you do or don't already have a license in place. We've put together a toolkit for successfully handling these changes in 5 steps. In briefly, these are to identify which roles will be impacted by the changes and any potential skills gaps, to review your internal systems and check that these are ready for the changes, to strategize around the appropriate options to follow, and to manage the change by aligning your next steps with the Brexit timetable and proactively implement your strategy. So we'll refer to and break down these steps in the following slides. So the first stage in our toolkit is to identify how you're going to be impacted. The questions you should be looking at are: what percentage of your workforce are EU nationals? Where are they based? What are your future recruitment needs? Think about your geographical footprint and how you can better accommodate the supply and demand of your business talent. So if the UK talent pool, that is those who can work in the UK without immigration restrictions, is reducing in size, you'll experience skills gaps. And how can these impact your operations? For example, if there are business critical roles you may need to recruit for where you need to sponsor an EU or non-EU national from January, you should start applying now for a sponsor license if you don't already have one in place to minimise delays or disruption. With the impact of COVID-19 on processing times, it's possible that we may start to experience delays in the processing of license applications. So we're going to look at this in the context of an example. So we've got Oktoberfest Brewing Company. They're a German brewing company based in London, and now that they're doing well, they want to recruit a wholesale manager with knowledge of the German brewery trade to help grow their exclusive German brew. They plan to recruit from February 2021, and they've identified who they want to bring to the UK, and the person is a German national. So if the person's able to come to the UK by the end of December 2020, they're eligible to apply for the EU settlement scheme, and they wouldn't need sponsorship. They may even be able to apply if they've only been in the UK for a day or so in the last 6 months. So let's say this person, for personal reasons, they can't arrive in the UK until January 2021. Oktoberfest Brewing Co. will then need to apply for a sponsor license, and the person will need a job offer and a sponsored visa. So now we need to look at what is Tier 2 sponsorship, like what kind of responsibilities the company going to be taking on by becoming a sponsor, and is becoming a sponsor a feasible solution for this company? So what is sponsorship? The current definition is permission in the form of a sponsor license, which enables organisations to sponsor non-European migrants who wish to work in the UK. Tier 2 of the points-based system is the primary immigration route for non-European Economic Area migrants who wish to work in the UK. A licence is a permission given to an organisation to sponsor workers in its business. The organisation is known as the sponsor, and individual persons are not recognised as a sponsor. Sponsorship itself is based on 2 principles. It's that those who benefit most directly from migration, which are people like employers, education providers, or other bodies bringing in migrants, they need to play their part in ensuring that the system isn't abused. The second principle is that the government needs to make sure that those people who are applying to come to the UK for work or to study are eligible, and that a reputable employer or education provider genuinely wishes to take them on. The prestige of having a license is referred to as having significant trust placed in the license holder. Having a sponsor license in place places an onus on the sponsor to be responsible for adhering to the strict rules and guidance issued by the Home Office. And these responsibilities are commonly referred to as sponsor duties.
So after deciding to apply for a sponsor license, the next step in our toolkit is to review and strategize. So you'll need to review if you meet the 4 requirements businesses need to apply for the sponsor license. The first is that you need to be a genuine organisation operating lawfully in the UK. This is evidenced in your supporting documents to the licence application. The type of documents required vary depending on whether your business is a startup or an established company. Secondly, you must be honest, dependable and reliable. The Home Office will consider the history and background of the company and key personnel named in your application and any people involved in your day-to-day running, including the person with overall responsibility for the license, called the authorizing officer, and your executive and HR teams. They may look at whether your company has previously incurred a civil penalty for illegal working, for example. Thirdly, you must be capable of carrying out your sponsor duties and evidencing compliance. The Home Office can look at your current HR and recruitment practices to make sure that you will be able to fulfil your sponsor duties at any time prior to or after granting the license. They can check this by visiting your premises to conduct an audit or by requesting documents to show that you meet the requirements. A key part of the review process will be to assess whether you have sufficient systems in place to meet the 5 areas of sponsor compliance, which are monitoring immigration status and preventing illegal working, maintaining migrant contact details, record keeping and recruitment practices, migrant tracking and monitoring, and other specific sponsor duties. Finally, you must be able to show that you can offer genuine employment that meets the minimum skill and salary level. You'll need to provide information regarding this in the license application and provide further justification if required. The decision to apply for a sponsor license should be part of a wider strategy that you should create by carrying out scenario planning, looking at the risks, opportunities, and impacts on your business critical functions of the upcoming changes in relation to the business's short and long-term goals. This will involve in particular creating workforce planning and compliance strategies to prevent disruption to your business. As we have already mentioned, the new UK immigration system means organisations will face restrictions on access to lower skilled labour. UK unemployment levels are currently high and there's a larger pool of available talent. The current resident labour market will be thinking about upskilling and retraining into new areas. This means that you may need to be thinking about tapping into different talent pools, upskilling and retraining existing workers, and looking strategically at international hires. Financial planning will be integral to any successful strategy, and this should involve planning in good time around the numbers requiring sponsorship and factoring in a sufficient budget. Alongside costs, there are compliance risks and administration burden associated with sponsoring workers. Once a strategy has been created, the final steps will be to manage and implement the change. People are understandably concerned about stability of their organisations at the moment. It's important to communicate your strategy in good time to teams implementing the change and to staff members where appropriate. So you may need to provide training to your HR and recruitment teams in implementing the processes. You'll then need to apply for a sponsor licence. You'll need to gather the required supporting documents to show that you're a genuine organisation, ensure that you have the appropriate HR systems in place, submit the online form and confirm that you do not have any unspent criminal convictions or a history of breaching immigration laws. You must pay the correct fee, which is currently £536 for small and charitable sponsors and £1,476 for medium and large sponsors. And you should note that in some circumstances, after a refusal, you can be excluded from reapplying for 6 months. So it's important to get it right and take legal advice where necessary. And once you have the license in place, it needs to be renewed once every 4 years.
So what if you already have a license? How are these changes going to impact you? Well, we recommend that you follow the same steps to take stock and identify and act upon potential issues. The main points to consider are as follows. Identify business critical roles. Identify who constitutes your workforce population. Who are you going to need to recruit in the next 5 years? Do you have any upcoming EU hires? Can you ensure that they arrive before the end of the year? Will you want to sponsor in medium skilled roles in the future? And do you plan to sponsor EU nationals? These are critical questions you need to be asking yourself. The volume of migrant workers that you will be responsible for is likely to increase. You need to review your internal systems and HR files, ensure that you can continue to facilitate the appropriate document checks, such as the right to work. This may include recategorising your workforce and reviewing your right to work and other policies to ensure you remain compliant with the rules on the prevention of illegal working. Are there any compliance risks which mean that you may fall foul of your sponsor duties? Consider auditing your existing systems, test them, remedy any failures now before you become inundated with an influx of responsibility. For example, has there been any change of ownership in your company due to a merger or an acquisition, which could require reporting or mean that you need to apply for a new license? Do you still have any key personnel in place with access to the system, and is the information on the system current? Your HR and employment teams need to be updated on the granular detail of the new immigration system from a human resources perspective. They may need a refresher in training, for example.
So we'll just look briefly now at the EU settlement scheme. So more than 3.7 million applications have been made to the scheme, but it's worth bearing in mind that this does not account for multiple applications made, and there are still many people yet to apply. So you may assume that your EU national employees already know about their legal position and the details of the EU settlement scheme, but many do not. We've been recommending that employers provide communications to their EU national employees, signposting government guidance on the EU settlement scheme. This is a good opportunity to provide employees with support and assistance where necessary, and to reassure them that there's no risk to their right to stay and work in the UK, provided they apply prior to the deadline on the 30th of June 2021. Any support you provide may go some way to retaining your existing workforce, reducing future recruitment costs. So EU nationals can rely on their passport as proof of their right to work up until the 30th of June 2021. And you cannot require them to provide proof of having applied to the EU settlement scheme before that date. But you may want to ask if employees are willing to share proof of their status that they have obtained under the scheme. And it's worth just bearing in mind that you can complete an online right to work check where the person either holds a biometric residence permit or status under the EU settlement scheme.
Okay, now we're going to have a look at the takeaways. So what are the key things that you need to be thinking about going forward? The first is that there is less than 6 months to go now until the new immigration system kicks in. You need to keep yourself updated regularly. Things are changing all the time. Keep communicating with those responsible for implementing changes and with your workforce. And take advice where necessary. It's important to stay proactive. So thank you for joining us for our webinar. We're now going to have a look at some questions. So we've had a couple come through. The first one for you, Jill, is how do the changes impact on my existing sponsored workforce?
Thanks, Pip. So if you have existing sponsorship in place with existing employees, sponsored workers, then sponsorship continues as normal for them. If anything, there is some increased flexibility that has been announced in the new system. So for example, my understanding is that if you're in the intra-company transfer category, for example, then you can switch into the skilled worker category once the changes come into effect, where you're not currently able to do that. So there may be some benefits when you come to extend your visa or switch your visa under the new system. Otherwise, there's nothing that you need to be doing in relation to existing employees that you normally wouldn't be doing anyway.
Okay, great. I've got another one here saying there's a lot going on at the moment for HR. How urgent is it that they need to look at immigration issues now?
Thanks. So yeah, I mean, it really what we've been saying in the webinar really is that there is quite a lot to think about and to put in place. And you don't want to be in a position in January where you might have long delays in bringing in essential staff while you complete the sponsor licensing process. So we've experienced a lot of delays in visa processing due to COVID-19. And it's possible that by that time or this year, we could see extended processing times for sponsor licensing applications. So if you anticipate that you might have any requirements for sponsorship of EU or non-EU nationals from January, then you should be applying really now for a sponsor license to avoid any delays. And it's also, I think we mentioned a few times, important to factor in the costs of applying. So if you haven't factored in a budget for additional immigration costs, this is likely to cause internal delays and approvals in your organisation potentially, and disruption to your business continuity. It's also a really important time to look at your compliance systems, given that there'll be an increased administration burden for sponsoring European nationals from January. So the Home Office can come and audit at any point during the time that you hold a license. So it's really important at the moment, especially when there's a lot of change, that you make sure that you do have the correct systems in place so that you don't end up with a civil penalty for illegal working, say, or having your sponsor license suspended or revoked because of non-compliance. So it's important to make sure that you don't get caught with delays.
Okay, and then another question here says, how can I request confirmation from my staff regarding the status of their EU settlement scheme applications? Is there a risk of discrimination?
Thanks. Yeah, so in relation to, as I mentioned just now, in relation to the EU settlement scheme, people do have until 30th of June next year to apply. So you can't require them to provide proof that they've applied before then. And you can rely on they can continue to rely on their passports as proof of right to work. But there's a slight sort of disconnect really with the fact that from the 1st of July, it is probable that someone who hasn't applied to the EU settlement scheme wouldn't have the right to work any longer. So it will be a question of communicating with your employees in a clear and transparent way, reminding yourself that you can't require them to provide proof of status, but I think that you can ask if they're willing to share proof of their status once they have obtained it. And I think probably in most cases, employees will be willing to share, will be very happy to share proof that they've applied to the scheme, as it looks as if many have already done so. Having said all of that, I'm not an employment lawyer, so you should always seek employment law advice if you have concerns about discrimination.
Okay, great. I think we might have time for one more. So we've got one here. So the majority of people who we sponsor are ICTs coming from America. It looks like the changes are positive for us. Am I understanding that correctly?
So in terms of ICT route, it looks as if they can switch into what's called the skilled worker route, which is the new name for the Tier 2 general route, which wasn't previously possible. So it does look as if there's going to be some increased flexibility, including more flexibility around the cooling off period. So the period where you're excluded from reapplying after you have a visa. So it does look like there is increased flexibility in quite a number of areas, including the ICT route.
Okay, great. Thanks, Jill. So thank you, everybody. I think that's all we've got time for today. I'd just like to bring your attention to, we've got 2 more webinars left in our series. One next week on the 21st of July, which is best practice in providing pensions. And then the final one on the 28th of July, which is an employment tribunal update. Previous webinars are available on the Field Fisher website and our YouTube channel. Thank you so much for joining.